Well, good morning.
Morning.
The next case before the court is Marilyn Hunt versus James Lightfoot. I see that both attorneys are present, so I will turn it first over to counsel for appellant to begin when you're ready.
Good morning. May it please the court. My name is Warren Kwabnik. I represent the defendant below, Marilyn Hunt. If I may, I'd like to reserve 5 minutes for rebuttal, please. I understand I have 15. We're asking the court in this case to reverse a judgment in excess of $11.5 million and that the court remand for a new trial or alternatively for a remittitor. We've raised a number of issues on appeal. To the extent I can't address all of them today, and I expect I won't be able to, I'm going to ask that I rest on my brief for those. On the first point that we've raised regarding the excessiveness of the award in this case, we acknowledge, of course, the deference afforded to juries in assessing damages and the discretion given to trial judges. We acknowledge that. However, in the very cases cited by my opponent, to emphasize that discretion, the appellate courts found personal injury awards for pain and suffering to be excessive and set them aside. That was done in a number of the cases that, in fact, were cited by my opponent as well as my own cases. And what that demonstrates to us is that Florida appellate courts should, can, and do set aside excessive awards in personal injury cases when appropriate. And that's what we're asking the court to do here.
Counsel, I wasn't clear on your argument. Are you saying that the award shocks the judicial conscience or that it was influenced by passion or prejudice, or are you saying both?
We're saying certainly it should shock the judicial conscience. One of the tests for whether it shocks the judicial conscience is if it is so high as to be indicative of having been the result of passion or prejudice. Another test is whether it exceeds the maximum. We can't point to anything in particular about was it influenced by passion or prejudice. I don't know that you ever could. But this is so high that we say it should shock the judicial conscience.
Well, can I ask you, is there some ratio? I mean, that would seem that the economic to non-economic, you're not challenging the economic damages of almost 1.5 million, right? It's just the non-economics that are here. The non-economics were a little over 6 times the economic damage for both past and present pain and suffering and such. Is that shocking? Are there cases that say 6 times, 8 times, 100 times is shocking?
No, and we're not relying upon the ratio, although I think the ratio is over 7 times the economics is what the non-economics were here. Our position is really, I consider that to be a fairly arbitrary comparison, economics to non-economics. But if we were to look at it, there are some older decisions that in passing note the relation between the economic and non-economic. There's no to the extent they do that, I don't think any court has said there is a ratio that determines excessiveness. And I don't think that's what we're looking to primarily. However, if the court was to look at that, it is multiples higher, I think at least 7 times higher of an economic award that's already a very generous economic award. But to answer the court's initial point on that, you're right. We're not specifically challenging the economic award. We're absolutely challenging the non-economic award and by extension, the totality of the award. But I think there's considerations much more pertinent than the ratio of non-economic to economic, although I think to whatever extent that's relevant, it does support us. I think by any metric, the award of nearly $12 million in this case, $10 million for non-economic, should shock the judicial conscience. We've supplied to the court reported verdicts that were generous in their own right, that are completely dwarfed by millions and millions of dollars by the award in this case. What I would also suggest is that this court's collective judicial experience with matters like this and an understanding of the philosophy of compensatory damages, I would respectfully submit should lead this court to conclude that this is a completely unsustainable verdict in this case.
Did you were you able to share those comparable verdicts with the trial court, or stated differently, what information was provided to the trial court to have the judge provide a basis of comparison between other arguably similarly situated verdicts?
Right. These verdicts were not supplied to the trial court. My opponent has, I think, analogizes to a failure to preserve an issue, but that's not correct. The excessiveness was raised. there's no reason in my mind why the court can't consider this the same way, you know, if there was an ALR article canvassing verdicts throughout the country, we could point to that. But what was provided to the trial court was at the trial court saw the evidence. The trial court should have been in a position to decide what, frankly, everyone should already know, which is this is a grossly excessive verdict. You
would agree that we analyze it under an abuse of discretion standard, correct, such that we would have to find no reasonable trial judge, not just that, you know, one of us or, you know, another judge might have remitted it down some, but no reasonable trial judge, right?
Understood, and that's what I began by acknowledging. We understand the discretionary standard of review, but this is not a close call. This is a massively excessive verdict in this case. And again, the cases cited in the brief, including by my opponent, those cases all begin by acknowledging the deference afforded to the trial court, and then go on to find a non-economic award to be so excessive as to be an abuse of discretion to have denied review. You know, there's one case in particular my opponent cited in her brief, and it was a quote that really stuck with me. It was from the Smith case, and it was cited by my opponent, and this is from the Smith case. It says, "The order comes to us properly boxed in the wide discretion of the trial court on the question of new trials, carefully wrapped in a presumption of correctness and securely tied with the strong cord of a jury verdict." You know, that I think gets to the point of what Your Honor is suggesting as far as the discretion. And what the court went on to say is, none of these are lightly regarded. We are also aware of the meaningless, yet often hurled accusation that a court, in setting aside a verdict as excessive, usurps the prerogative of the jury. However, we have a duty to review the amount of damages awarded in this case for the simple reason that the question has been properly presented to the court by the appellant. We do not sidestep this duty. We do not sidestep this duty to review, which is not in derogation of the right to a jury trial. I might have misread that slightly, which is in derogation of the right to a trial by jury, but which is rather one of the historic safeguards of that right. And the court went on, notwithstanding the original poetic language about the deference, they went on to set aside a pain and suffering award as being excessive, such that it was an abuse of discretion. So I do understand the standard of review, but I think this court has the power, certainly, and respectfully, the obligation to protect litigants from oppressive and excessive awards of the kind we have in this case. The legislature, in enacting the remittitor statute, provided specifically this power, which already existed by common law. And this case, I would say, is the poster child for why we have that authority. This is the case for which that authority exists, I would submit. I'm already cut well into my time. I do appreciate the court, of course, giving us the oral argument time. I want to address any questions that the court has on this before I move on to the next point.
Well, I actually have one additional question, and I know this was raised in the briefs, but you know, appellee points out that there was no guidance offered to the jury as to the methodology that it should use in determining the non-economic damages, and it cited some cases that says, well, that kind of undercuts an argument on appeal that a jury verdict is excessive. Would you address that for us?
Certainly. The case primarily cited by my opponent for that point is a case called Ailes, I think. That court acknowledged that the defendant in that case had not provided any guidance to the jury, and yet they did affirm a remittitor in that case. What I would say is, you know, what the lawyers argue, as the court knows, is not evidence. It's guidance, it's argument. Nothing about what's argued in closing should prevent the court from reviewing the damages award, which is limited by the evidence in this case. The plaintiff suggested a methodology to the jury, a per diem or a time value consideration. The defense argued that there wasn't permanency and therefore they shouldn't even reach the non-economics. But ultimately, the jury is properly constrained by the evidence. If the court looks at the standards imposed by the case law and by the remittitor statute, none of it is what was argued to the jury. It all is in relation to the evidence. And I would say that although the jury was not given specific amounts by either side in this case, other than the defense saying there wasn't permanency, nothing should prevent appellate review based on the evidence of the judge's denial of the new trial and remittitor. Have I answered Your Honor's question on that?
Thank you.
Thank you. One of the issues, apart from the verdict itself, was the court's denial of an update medical examination. That's an important issue here. And I think the backstory briefly is 8 years after the accident and after 7 years of litigation, but only about 60 days before the trial, the plaintiff came into his update deposition in a motorized wheelchair for the first time in the case. That was an important development.
Counsel, I don't want to get into your rebuttal time, but the request, as I understand it, the dates, and correct me if I'm wrong, he was seen in the wheelchair on June 4th at his update depot, but there wasn't a motion for an updated exam until July 30th. And that was one of the factors that the trial court used in denying the updated exam. Is that correct?
That is correct. We contend that that wasn't an appropriate reason to deny the examination. When defense counsel, shortly before trial, about 60 days, was confronted with this, there was a lot of scrambling and a lot of efforts to get up to speed. If Your Honor sees, there was a lot of motion practice trying to get update depositions of 2 doctors in that meantime.
Can I ask you again, how is the denial of the update prejudicial, since Dr. Norman had said no causation previously? So at best, an update would show causation, which would hurt the defense case, not help the defense case.
Well, that's one of the reasons that the court came up with, and a few points about that. One, when Dr. Norman last examined the plaintiff about 3 years earlier, there was no issue of a wheelchair whatsoever. The wheelchair needed to be specifically addressed. I don't think it was sufficient for him to simply say there was no causation of anything. The wheelchair itself was a meaningful change. There's every reason to believe something also material happened in those 3 years to require the wheelchair. You know, when the plaintiff comes into court with his doctors saying, I prescribed this wheelchair because I treat him consistently, he's having these falls and he's degenerating, and all the defense is able to say is, well, our doctor examined him 3 years ago. There was no issue of a wheelchair at the time, but he sees no reason why his opinions would have changed. That's not a sufficient response. He needed to be able to specifically address the wheelchair. The wheelchair was not in play 3 years earlier. No one could have foreseen it, contrary to what the trial court determined. It wasn't foreseen by the plaintiff's attorneys, the plaintiff's life care expert, whose job it is to predict and recount the future treatment. So what I would say is, why did it prejudice us? Because we were left unable to address the wheelchair, as opposed to a broad issue of causation. That needed to be specifically addressed. All our expert was able to say at trial is, he didn't see anything in the records that he had reviewed that would warrant a wheelchair. He really was unable to address the wheelchair specifically, and we think that was unfair. The other point also, if I could, a second response I have to Your Honor's question on this is, by saying that the defense wasn't prejudiced because the doctor's opinion was not going to meaningful change, I think that is completely inconsistent with another part of the court's reasoning, which is the plaintiff would be prejudiced by an examination because he wouldn't get to know what the medical expert was going to say. Well, if his opinion was not going to change, or if it was, it would only be for the plaintiff's benefit, then how could the plaintiff be prejudiced by that? So, you know, those two aspects of the court's reasoning, I think, are inconsistent. But the primary issue here is we were left completely unable to address the wheelchair by medical examination. And a primary consideration by the court in that regard was the court simply took for granted, well, this is just continued degeneration from the car accident. No, that's the issue. That's what the expert needed to address. It was inappropriate, we say, to deny an examination on the conclusion that all this is just due to the accident. That's what he needed to determine. If there's no question on that, there's one other point in my brief I would like to address today, and that pertains to the witness coaching issue. That's the final point in my brief, and the problem here, I need to make this clear because from the response, I'm not sure I thought I was clear. The problem that we're asserting is that the court erred by not allowing the defense to conduct an on-the-record inquiry of the bailiff.
Well, did she ask for an on-the-record inquiry of the bailiff or Cleve or plaintiff or anybody to say what was going on there?
Not of Cleve. We didn't reach the point when we needed to get Cleve or the plaintiff on the stand. The critical witness here was the bailiff, and we do think it was requested. I understand my opponent's argument that this wasn't preserved, but I've addressed a number of reasons in some degree of detail in the reply brief why I think it was preserved. What happened here, the bottom line is the court was made acutely aware of what we wanted to do. the court was told we would like this entire matter ferreted out. We want to make a record. And counsel said, had she been quicker on her feet, she would have asked when the matter came up a day or so earlier to have the bailiff put her observations on the record. And the court said that would have been denied. So I think in terms of preservation, when the court is acutely aware of what we would like to do and says that would be denied, I think we've been denied the relief. And in fact, if you look at the plaintiff's answer brief, I think 46 or page 45 or 46, they acknowledge that the court's comments that would have been denied meant that the court would have denied the request when the matter first came up, and the court would have denied the request then. So in terms of, in a sense, it would have been futile to go any further. But we know for fact the court knew what we wanted to do. We wanted to make a record. We wanted this ferreted out, and we wanted to have the bailiff put her observations on the record. And the court said that would not be allowed. Now, the problem that we have now is the court's handling of the situation. The court's denial has left its handling of the matter to be completely impervious to appellate review. When the bailiff reported what she reported to the court, what the court could not do was an unannounced, off-the-record private discussion with the bailiff that apparently involved intense questioning from which the court reached an impression that the bailiff wasn't certain of what she saw or what she didn't see.
Counsel, you're actually, you're out of time, but I will extend your time for 2 minutes on rebuttal, but I would like now to turn it over to counsel for appellee.
Thank you.
May I please support Rebecca Creed on behalf of the plaintiff appellee James Lightfoot. We ask this court to affirm the final judgment on the jury's verdict and to affirm the trial court's orders denying remittitor and denying new trial. I will attempt to address the issues raised in the initial argument, but to the extent I don't get to those, I'd like to rely on my answer brief as well. The trial court first did not abuse its discretion in denying the defendant's motions for new trial and remittitor. As this court is aware, assessing the amount of damages is clearly within the jury's province, and this is especially true in measuring non-economic damages, which are inherently difficult to measure because there's no objective standard. And here the jury was instructed that the amount must be fair and just in light of the evidence. So where the trial court, as it did here, refuses to grant remittitor, denies remittitor and new trial, the Florida Supreme Court in its Odom decision has reminded us that correctness of the jury's verdict is then strengthened, citing the Lassiter decision, which was one of the bases for our standard of review discussion in the initial brief, in the answer brief. The cases that we rely on to establish the standard are applied by the Florida Supreme Court in its 2018 decision in Odom, and also applied by the 4th District in its second Ailes decision. And there, especially in Odom, the Supreme Court uses those standards to set aside and to find that there was a misapplication of the abuse of discretion standard and that remittitor was not warranted. Again, the discretion is both given to the trial judge in its review and also to the jury itself, because the difference is due to the trial judge who had the opportunity to observe the witnesses and to consider the evidence in the context of a living trial rather than upon a cold record. And again, deference is given to the jury's determination for the measure of damages.
Counsel, so I think we recognize this is a heavy burden for appellant in this case, but it's not necessarily insurmountable. Can you cite us to any appellate decision that's upheld a verdict of this size in a non-death case?
In a non-death case, I would have to frankly research that. I do not know that I could point you to one today, but I would argue that certainly the cases that we cite in our answer brief, especially Odom, do give strong support to the trial court's refusal to set aside this jury's verdict. None of the criteria are met under section 768.043. The verdict is supported by the evidence, bears a reasonable relationship to the plaintiff's injuries, and doesn't suggest that the jury was unduly influenced by passion or prejudice. Essentially, the defendant's argument is that because this verdict is just excessive, because it just is, but there's nothing to point to the fact that the amount awarded was indicative of passion or prejudice. Certainly here there were significant injuries, multi-level injuries to the plaintiff's spine, both at the cervical disc level and the lumbar disc level. Counsel points out in the reply brief that I misstated the extent of the injuries, and it should have been one herniated cervical disc and one bulging disc in the cervical spine. But one radiologist, the plaintiff's expert radiologist, described the lumbar injuries as being two herniated discs. So in any event, there were acute injuries and aggravation of a pre-existing degenerative condition. There was significant reports of pain and suffering by the plaintiff that continued from just as soon as the day of that accident, diagnosed within 5 days of that accident by objective indications from an MRI. The award doesn't speak for itself, even though counsel argues that the court doesn't have to investigate and specifically find what wrongful influence brought about an excessive verdict. As the Florida Supreme Court reminds us in Odom, at least you have to show at least enough of an inference of that the verdict implicates passion or prejudice. This is not a case where, like the Gladman decision that we cite in the answer brief, there's no indication of passion or prejudice where the witness, the court staff, and the trial judge were all crying. And so here, even if this court may not agree with the jury's verdict, it should not be set aside unless it's so inordinately large as to exceed the maximum range within which the jury could properly operate. Again, there's no indication that the jury took improper elements of damages into account. There was no objection to the plaintiff's counsel's suggestion in closing argument that the jury should consider basically awarding a per diem amount for each day of the plaintiff's suffering, multiplied by consideration and not only of each element of the non-economic damages award, pain and suffering, disability, disfigurement, impairment, loss of capacity for the enjoyment of life, but also as to each of his waking hours, and then calculate that by day and by year. This is not an improper measure of damages. It is relevant to show that the jury calculated a damages award in a logical manner, which is one of the elements for deciding whether or not to grant remittiture under the statute. There's a lack of speculation and conjecture by the jury. And as this court has pointed out, there was no guidance given to the jury for calculating an award of non-economic damages by the defense. So
let me ask you it really is just underscoring, my question is going to underscore the difficulty of the decision for this court, and it's been recognized by other courts, related to the inherent difficulty of determining whether a jury verdict is excessive. But what if the time unit methodology used here yielded a verdict of $20 million? And where is the line of that is to be drawn that it shocks the judicial conscience?
Well, because it is a standard of review, it is an abuse of discretion standard, I think we would first need to begin with whether it shocked the trial court's judicial conscience. And here, the trial court denied remittiture. She was the one who sat through the trial, observed the evidence, the impact on the jury. And so that should be a decision, and it is a decision that's primarily within her purview to decide whether it shocks the judicial conscience.
Do you think, counsel, that the ratio that I had suggested earlier has anything to do with it? And if so, what ratio is so high that it shocks the judicial conscience?
Again, I'm not sure there's any formulaic determination in the case law for, in this context. This is not like a punitive damages comparison. I believe the ratio, to the extent it's 6 or 7 times the economic damages, which here were significant, it's not one that shocks the judicial conscience. And respectfully, I don't think this court has to decide today on the facts of this case that, or it doesn't have to establish going forward what ratio would be unacceptable. Certainly on the facts here, which should be determined, this case has to be determined on its facts. there's nothing to show that the trial judge abused her discretion in setting aside this, or excuse me, in refusing to set aside this jury's verdict. And as the Florida Supreme Court has reminded us, comparison to other verdicts can be especially tricky, especially whereas here this information wasn't provided to the trial judge in the first instance. But even if this court does consider that, comparisons have to be made with caution, because no injury is exactly like another. Different individuals can be affected to a greater or lesser degree by similar injuries, and that's what's shown by the verdicts that are provided. First of all, there's no set of verdicts and no set of facts on the verdicts provided by the defense that exactly match up with the kinds of injuries, the multiple level disc injuries and permanent aggravation that this plaintiff experienced. Some of the verdicts are dated, and only 2 are from the Fourth Judicial Circuit. So again, there's not a need to make a strict mathematical comparison, and here there is a failure of the defendant to show that the trial judge abused its discretion in refusing to grant remittitor. The correctness of the jury's verdict should be strengthened by the denial, and the defendant is not entitled to remittitor or to a new trial. As to the CME issue, again, the update CME was not just an update CME, it would have been a third CME by the same defense expert, Dr. Norman. That again is reviewed for an abuse of discretion. The case law in Florida requires a stronger showing to satisfy good cause for a subsequent CME when there is such a request as there was here. And here that burden wasn't met. It is the defendant's burden under Rule 1.360 to satisfy and to show good cause. And the plaintiff's right to bodily privacy needs to be balanced against the need for information and to limit the number of exams to the minimum necessary. So here there was no substantial change.
Ms. Creed, on that point, what's your response to Mr. Kwavnik's argument that they had no inkling about the wheelchair until he showed up? So there was no way they would have known about it until that date. And it seems like showing up in a wheelchair when you've never been in a wheelchair before, that is a significant change that would justify even a third CME. What's your response to that?
Well, first, the standard is not just whether there was a significant change, but whether there was substantial change in the plaintiff's physical condition. And so the defense essentially points to the wheelchair and says, well, that in and of itself is like a surgical procedure, or that wheelchair in and of itself reflects a substantial change in the plaintiff's physical condition. But the wheelchair, like a cane or like crutches, is a device to assist the plaintiff with his mobility. It was another method of treating the plaintiff's injuries. And certainly the defendant had long known of the degeneration of this plaintiff's condition, had long known of the extent of his injuries, and the underlying physical injuries, the disc herniations and the bulging discs and the aggravation to pre-existing degeneration, none of that had changed since the second CME by Dr. Norman in 2016. So this wheelchair was consistent with the plaintiff's ongoing treatment, of which the defense was well aware, and it was not as if the nature of his injuries had substantially changed. And again, it is the defense's burden to show good cause. And here the trial court essentially found that that burden had not been met. It's not as if the trial court was attempting to make her own medical determination, but in the absence of a showing by the defendant that there was a substantial change in the plaintiff's physical condition, the trial court certainly could rely on the deposition testimony of Dr. Cartwright, who was responsible for treating this plaintiff. He found that the plaintiff had continued to degenerate and continued to treat for pain. And because of that pain and the risk of falls, the wheelchair was a relatively low risk treatment that the plaintiff was entitled to. Again, the defense had already had 2 CMEs to evaluate this plaintiff's physical condition. Dr. Norman had opined in in the fall of 2016 that the symptoms were all degenerative, and that none of the injuries were caused by or related to this crash. So there was no prejudice to the defense because Dr. Norman's opinion had already been established, and to the extent he would have changed that by examining the plaintiff for a third time, any change would have been necessarily to the plaintiff's benefit. And so there was no justification, no good cause shown. The defense chose its timing. Certainly the defense could have asked for an update deposition of the plaintiff before mid-May or early June. The defense could have chosen to seek updated discovery before it did. While discovery technically was closed according to the pretrial order, the parties had been cooperating in terms of scheduling update depositions, but the defense should not be entitled to wait until just 2.5 months before trial to seek the plaintiff's update deposition, and then wait even then from June 4th to July 30th to file a request for a third CME. As to the final argument on the witness coaching, the defense did not timely request any on-the-record interview of the bailiff. The trial court fully informed counsel what she had learned on the Thursday afternoon of trial. Defense counsel stood silently by, made no objection, made no motion for mistrial, made no request to interview the bailiff at that time. And only on Monday morning, after all the evidence had closed, did the defense make that motion for mistrial. May I have just a few minutes to wrap up, or a few seconds to wrap up?
You may briefly conclude. Thank you.
And so for all the reasons that we explained in our answer brief, there was no refusal to make a record. There was no abuse of the trial court's discretion in its ability to control the witnesses and the method and mode of interrogation, to control its courtroom. And there was nothing shown in the affidavits even that the defense counsel submitted in support of the motion for a new trial that were any different from what the trial judge had already explained to the parties. We also submit, to the extent the defense tries to rely on a motion to interview a juror, comparison that by analogy, there's no showing of enough of a ground to grant a new trial based on the speculative possibility of witness coaching. So again, for all those reasons, we ask this court to affirm. Thank you.
Thank you, Ms. Creed. Mr. Kwavnik, return it to you.
Thank you, Judge. I understand I have 2 minutes, and I appreciate that. Let me handle these in somewhat reverse order, starting with the CME point. The standard is not whether there was a substantial change. The standard is whether there is good cause. We understand that good cause for purposes of a successive examination requires a stronger showing of necessity. That's per the Cox case. But the court needs to understand the standard of good cause for the initial examination is very, very low. It's simply that there is an assertion of a bodily injury. We know from the Cox case that the denial of a third CME in that case warranted the granting of a petition for writ of certiorari. So even a third CME could be an error to warrant the granting of an extraordinary writ. We have that here. I understand that there was some criticism. Why didn't we do update discovery sooner than June of 2019? Well, the plaintiff only had his wheelchair in March of 2019. We never would have known about it with an update deposition in January or February, or maybe not even in March. So, that's a misplaced criticism. And again, I think it really is unfair Monday morning quarterbacking to criticize the defense in their ability to handle this new important information, scrambling as they did, to use that as a reason to deny them an important examination on an important development in the case. Going back to the excessiveness of the award, even now, we've not heard anything to demonstrate that this is the kind of devastating or catastrophic injury that could warrant an 8-figure verdict. I understand your question, Judge Ray, where do we draw the line? This court doesn't have to draw the line. This was addressed in the Lofton versus Wilson case, where the Supreme Court reversed a non-economic award, and they said, well, what amount is the plaintiff entitled to? And what they said is, well, we don't decide that, the jury decides that, but it's got to be a jury determination that's not infected with a verdict indicative of passion or prejudice. This court doesn't need to decide what the maximum is. This court needs to know and needs to find that the maximum is way below the 12 million. This is beyond, 12 million is completely unsupportable by, again, any metric. The verdicts we've supplied, which are millions of dollars less than what the jury awarded here, the court's common sense, and I think Ms. Creed's tacit acknowledgement that she can't point to a single non-death case supportive of the verdict in this case.
Thank you, counsel. You're now out of time again, and we do appreciate so much both counsel's arguments before us today. We will take the case under advisement, and the court is now adjourned.
Thank you.
Thank you.